There comes a point in every long life when you begin to recognize the sound of an ending before it is officially announced. And January 2nd feels like one of those moments, because this is not just another bad headline for Sean Diddy Combs. This is not just another day where his name appears in court paperwork. This feels heavier than that, slower than that, more final in its tone. For decades, Diddy stood as a symbol of dominance in an industry built on ego and excess. A man who moved with the confidence of someone who believed the rules were written for other people. He was the architect of an era where money talked louder than morals, where silence could be bought, where influence could delay consequences long enough for people to forget. But time has a way of stripping men of their illusions, and now, just 2 days into a brand new year, the weight of that time is pressing down hard. On January 2nd alone, multiple civil lawsuits surfaced again, some newly filed, some refiled, all pointing back to the same man, all circling the same types of allegations, and together they tell a story that no amount of money can fully bury. According to publicly available court filings that have been closely monitored by legal observers, Diddy has been served again in several matters, including Ward versus Combs, Michelle Mitchell versus Combs, Bleedo versus Combs, and Rose versus Combs. These are not petty disputes or contractual disagreements. These are serious civil actions involving allegations of sexual assault, battery, negligent supervision, and gender-based violence. And for those who have lived long enough to see patterns form and repeat, the significance lies not just in the accusations themselves, but in their repetition. When one person makes a claim, people argue. When two people make similar claims, people debate. But when multiple individuals across different times and circumstances come forward with overlapping allegations, the conversation shifts from disbelief to concern, and eventually to accountability. For an older audience, this moment resonates differently. You have seen powerful men fall before. You have seen families built on influence collapse under the weight of truth. You understand that real downfall rarely happens in one dramatic explosion. Instead, it unfolds slowly, almost quietly, through paperwork, depositions, hearings, and settlements. Civil lawsuits are especially unforgiving because they do not require a unanimous jury or proof beyond a reasonable doubt. They require persistence, documentation, and time. And time, ironically, is something Diddy no longer has on his side. Each new filing adds another financial burden, another legal obligation, another emotional strain. Lawyers must be paid. Insurance companies get involved. Assets are scrutinized. And even if cases are eventually dismissed or settled, the cost is never just monetary. The cost is reputation, energy, and control. This is exactly what Curtis 50 Cent Jackson meant when he publicly stated that Diddy's money would be drained by civil litigation. Not overnight, not in one dramatic judgment, but slowly, relentlessly, case by case. Civil court does not care how famous you once were. It does not care about awards, influence, or past success. It only cares about claims, responses, and accountability. And what makes this moment even more telling is that these lawsuits are not being driven by loud press conferences or media theatrics. This is not spectacle-driven lawyering. This is quiet, methodical litigation, the kind that operates steadily in the background while the public is distracted by something else. That is often the most dangerous kind, because it does not rely on attention to survive. It relies on procedure. As these cases stack up, the conversation around Diddy's wealth has shifted in a noticeable way. People are no longer asking how rich he is. They are asking what he is selling. Private jets, luxury properties, estates that once symbolized permanence are now rumored to be on the chopping block. And for those who have lived through economic cycles, who have watched fortunes rise and fall, this shift is unmistakable. When a man transitions from acquisition to liquidation, it signals survival mode. It suggests that maintaining appearances is no longer the priority. Staying afloat is. Wealth that once seemed endless begins to look finite when legal bills, settlements, and judgments enter the picture. Civil litigation does not just take money. It takes flexibility. It limits options. It forces decisions that would never have been considered during the peak years. The idea of a dynasty has also begun to crack under scrutiny. For years, the image presented was one of generational wealth, legacy, and continuation. But the truth, as it often is, appears more fragile. The next generation has not established independent empires separate from their father's shadow. They are not creating wealth on a scale that replaces what is being lost. Instead, they remain tied to a legacy that is now under siege. And when that legacy weakens, everyone connected to it feels the instability. Older audiences understand this well. A family name can open doors, but it can also close them just as quickly when that name becomes associated with controversy and litigation. What adds another layer of gravity to this situation is the fact that Diddy is not navigating these challenges from a position of freedom. He is incarcerated. He is physically removed from the centers of power and influence that once allowed him to manage crises swiftly and aggressively. Civil courts do not pause because a defendant is behind bars. Deadlines still exist. Filings still move forward. Plaintiffs still demand responses. And while legal teams can act on his behalf, there is something fundamentally disempowering about watching your world be dismantled from a distance. For a man accustomed to control, this is perhaps the most profound loss of all. This is why January 2nd feels different. It is not just about the number of lawsuits. It is about momentum. It is about accumulation. It is about the sense that this is no longer a phase that will pass quietly. For people who have watched history repeat itself, this moment feels familiar. Powerful men often believe their influence will outlast scrutiny. Sometimes it does for a while. But eventually, the paperwork catches up. The witnesses speak. The money thins. And the silence that once protected them begins to work against them. What we are witnessing now is not chaos. It is process. And process, once it starts moving, is very difficult to stop. This is only the beginning of the year. And already, the weight of the past is pressing heavily into the present. For those who understand the long arc of consequence, this does not look like a temporary storm. It looks like the early chapters of a reckoning that has been delayed for years, but is no longer willing to wait. As these lawsuits continue to stack up, what becomes increasingly clear is that this is no longer just a legal battle, it is a reckoning with time itself, because time is the one force no amount of money, influence, or reputation can permanently outrun. For decades, Diddy existed in a world where problems could be managed quietly, where settlements could be arranged behind closed doors, where unfavorable stories could be softened or delayed until attention moved elsewhere. That era is gone. The world has changed, the courts have changed, and public tolerance for silence has changed. Civil litigation, especially at this scale, does not operate on loyalty or nostalgia. It operates on procedure, documentation, and persistence, and that is why this moment feels so heavy, particularly for those who have lived long enough to recognize when power begins to erode not through scandal, but through exhaustion. Each new lawsuit carries its own weight, but collectively they create something far more dangerous, a pattern. Patterns matter deeply in civil court. They shape how judges perceive credibility. They influence how insurance companies respond. They affect whether cases are settled quickly or dragged through years of litigation. And they force defendants into positions where every decision has consequences. Settle too quickly, and you invite more claims. Fight too aggressively, and you risk discovery revealing more than you intended. This is the delicate, grinding pressure that civil litigation applies, and it is especially brutal for someone whose life has been built on constant forward motion and control. For an older audience, this stage of the story is painfully familiar. You have seen men reach the later chapters of their lives only to realize that unresolved choices have a way of resurfacing when strength begins to fade. Youth allows arrogance. Money allows delay. But age demands reckoning. The body slows down. The mind grows tired. The patience for endless legal battles wears thin. And yet the system keeps moving, indifferent to fatigue. This is where many powerful figures begin to lose not just their cases, but their will to keep fighting. The financial implications alone are staggering. Civil lawsuits do not come cheap, especially when multiple cases are active simultaneously. Legal teams must be retained. Experts must be consulted. Filings must be reviewed and responded to. Depositions loom. Discovery opens doors that defendants often wish had stayed closed. Even if some cases are dismissed or resolved quietly, the cumulative cost is enormous. This is where rumors of asset sales begin to carry weight. Private jets, properties, and luxury holdings are not just symbols of wealth, they are liquidity. And when liquidity becomes a priority, it signals that the financial picture is tightening. For those who have lived through financial downturns, recessions, or the collapse of once great companies, this stage is unmistakable. When assets are sold not to reinvest, but to sustain, the trajectory has changed. Wealth that once felt endless begins to feel fragile. And unlike younger men who can rebuild over decades, time is no longer an ally here. Every year matters. Every decision carries amplified consequences. The idea of legacy looms large at this stage. For years, Diddy cultivated the image of a man building something that would outlive him, a family name that would continue through generations. But legacy is not just about wealth. It is about reputation, trust, and the stories people tell when you are no longer in the room. Civil lawsuits rewrite those stories. They introduce doubt where admiration once lived. They complicate memories. They force descendants to defend actions they did not commit, but are nonetheless associated with. For an older audience, this is perhaps the most sobering aspect of all. You spend a lifetime building a name, only to watch it become a burden for those who inherit it. The younger generation connected to this legacy now faces an uphill battle. Without independent empires or clearly defined paths separate from their father's influence, they are tethered to his fate. Opportunities become complicated. Partnerships become cautious. Doors that once opened automatically begin to hesitate. And while youth may provide resilience, it does not shield anyone from the consequences of association. This is how legacies unravel quietly, not through dramatic announcements, but through subtle shifts in perception and opportunity. Meanwhile, the legal process marches forward. Diddy's incarceration adds another layer of complexity and vulnerability. Being physically removed from the centers of power changes everything. Decisions that once could be made quickly now require intermediaries. Strategies must be communicated through layers of counsel. Information arrives delayed. Control becomes fragmented. For a man accustomed to directing every aspect of his empire, this loss of immediacy is profound. It forces reliance on others at a time when trust is already under strain. Civil courts do not slow down out of sympathy. They do not pause for reflection. Deadlines remain firm. Judges expect compliance. Plaintiffs expect progress. And as months turn into years, the emotional toll compounds. Stress accumulates. Fatigue sets in. Even the strongest legal teams feel the weight of sustained litigation. For older defendants, this can be especially draining. The fight becomes less about winning and more about enduring. This is why January 2nd feels less like an isolated incident and more like a continuation of a trajectory already in motion. The new lawsuits are not anomalies. They are extensions of a broader narrative that has been building momentum for some time. And momentum, once established, is difficult to reverse. For those who understand history, this is the phase where outcomes begin to crystallize, where options narrow, where the illusion of endless control gives way to the reality of limits. What makes this moment especially sobering is the absence of a clear off-ramp. There is no single case that, if resolved, will make everything else disappear. There is no singular settlement that restores reputation. There is no public statement that erases years of allegations. This is cumulative accountability. Each case adds weight. Each delay increases cost. Each development draws more attention. And the system, once engaged at this scale, does not simply let go. For an older audience, there is a quiet sadness in watching this unfold, not out of sympathy for power lost, but out of recognition of wasted opportunity. There were moments when different choices could have been made, moments when accountability could have been embraced earlier, when harm could have been addressed, when reputations could have been repaired rather than defended. Those moments have passed. What remains now is process, consequence, and time. As the year unfolds, these lawsuits will not exist in isolation. They will intersect with other legal developments, other cases, other revelations. And each intersection increases complexity. This is how legal pressure compounds, not just through volume, but through connection. For someone already facing incarceration, the psychological burden of knowing that more battles await is immense. It weighs on every decision, every conversation, every night spent awake with thoughts of what comes next. This is no longer about shock or spectacle. It is about endurance. It is about watching a powerful figure confront the limits of influence, the cost of unresolved actions, and the reality that some chapters cannot be rewritten. For those who have lived long enough to see cycles repeat, this stage feels hauntingly familiar. The bravado fades. The noise quiets. And what remains is the slow, relentless movement of accountability, advancing one filing at a time. As if the mounting civil lawsuits were not already enough, the legal landscape surrounding this entire situation continues to widen, pulling more names, more narratives, and more unresolved questions into view. And for those who have lived long enough to understand how the legal system truly works, this is often the point where the story becomes less about headlines and more about patience, credibility, and endurance. One of the most closely watched developments involves the ongoing matter connected to Cassie and Clayton Howard, a case that carries its own emotional and symbolic weight because it touches on retaliation, public narrative, and the difficult reality of what happens when victims are forced to defend themselves long after the initial harm has already been done. In this matter, the court has granted Clayton Howard an extension of time to respond to filings from Cassie and her legal team. On the surface, this may appear routine. Courts grant extensions every day. Deadlines shift, calendars move, but those who have spent years observing litigation know that extensions often reveal more than they hide. Sometimes they indicate careful preparation, a legal team assembling evidence, refining arguments, and preparing for a sustained fight. Other times, they signal hesitation, uncertainty, or a recognition that rhetoric spoken publicly does not always translate cleanly into legal strategy when evidence and sworn statements are required. For an older audience, this dynamic is deeply familiar. Many people have watched situations where someone speaks loudly when there are no consequences, but grows quieter as accountability approaches. Interviews are easy. Courtrooms are not. Allegations can be made freely in public spaces, but once sworn testimony, discovery, and cross-examination enter the picture, the tone often changes. This is not speculation. It is the natural pressure of a system designed to test claims, not amplify them. And that is why this extension matters. It buys time, yes, but it also delays resolution, prolongs stress, and keeps wounds open. Now, for Cassie, this extension is not just a procedural footnote. It is another reminder that justice rarely moves quickly, especially for those who have already waited years to be heard. Older audiences understand this pain intimately. You know what it feels like to carry something unresolved for too long, to relive it through paperwork, hearings, and public scrutiny. Every delay forces victims to remain emotionally engaged with trauma they would rather leave behind. And yet, walking away is rarely an option, because silence is often interpreted as surrender. There is also a pattern that many seasoned observers recognize all too well. Some individuals seek the spotlight early, giving interviews, making statements, shaping narratives while public attention is high. But as legal pressure increases, as deadlines loom and evidentiary burdens become real, their presence fades. Extensions are requested, responses are delayed, energy dissipates, and eventually some disappear altogether. When that happens, it does not vindicate the initial claims. It simply reinforces the imbalance victims face when forced to defend their truth repeatedly, while others retreat when accountability approaches. If this pattern repeats here, it would not be surprising to those who understand the system. And while such an outcome might bring relief to Cassie in one sense, it would also underscore a harsh reality. Justice often comes not through dramatic victories, but through endurance, through staying present while others withdraw, through remaining consistent while narratives shift. For an older audience, this resonates deeply because endurance is something you learn over time. It is not glamorous. It is exhausting, but it is often the only path forward. Beyond this individual case, these developments contribute to a broader legal atmosphere that continues to surround Diddy and those connected to him. Each related case adds context. Each filing reinforces the sense that this is not an isolated controversy, but a network of disputes that intersect and overlap. This matters because courts do not operate in a vacuum. Judges are aware of broader patterns. Attorneys are aware of reputational context. Even when cases are technically separate, the cumulative effect shapes strategy, settlement discussions, and courtroom dynamics. For someone already facing incarceration and multiple active lawsuits, the psychological toll of this expanding legal web cannot be overstated. Older audiences understand the weight of stress that accumulates when problems multiply rather than resolve. It affects sleep. It affects decision-making. It erodes resilience. And when you reach a stage in life where energy is finite, that erosion becomes visible. The fight becomes less about proving innocence or guilt, and more about surviving the process itself. This is also the stage where public perception begins to harden. Early on, scandals are often met with curiosity or disbelief. People wait for more information. They reserve judgment. But as cases persist and new developments emerge, patience wears thin. Sympathy fades. Skepticism grows. For those who have lived through public reckonings before, this is the moment when narratives solidify. Changing minds becomes nearly impossible. The story people believe becomes the story they carry forward. What makes this especially poignant is the contrast between the early years of power and the present moment. There was a time when Diddy's name alone could end conversations, and redirect attention, or command loyalty. That power rested on momentum, money, and myth. But myth is fragile. It depends on silence and agreement. Once silence breaks and agreement dissolves, myth collapses under its own weight, and what replaces it is reality, unfiltered and unforgiving. For an older audience, watching this transition evokes reflection rather than shock. You have seen this before, perhaps in different industries, different eras, different names. The pattern repeats because human nature repeats. Power often breeds entitlement. Entitlement breeds risk. Risk ignored becomes consequence. And consequence, delayed long enough, arrives with interest. As these legal matters continue to unfold, there is no sense of closure yet, only continuation. Extensions granted, filings pending, questions unanswered. And this lack of resolution is itself a form of punishment. Living indefinitely under scrutiny, uncertainty, and legal threat is draining in ways that younger audiences often underestimate. It is a slow wearing down of spirit, confidence, and identity. For those who built their lives on certainty and control, this state of limbo is perhaps the most destabilizing of all. This is why part 3 of this story feels less dramatic, but more revealing. There are no explosive announcements here. No sensational revelations. Just process, delay, pressure. And for those who understand the legal system, that is often where the real story lives. Justice is not always loud. Sometimes it is quiet, patient, and relentless, advancing not in leaps but in inches. And as these inches accumulate, they move everyone involved closer to a point where choices narrow, defenses weaken, and outcomes become unavoidable. For Cassie, for Diddy, for every name connected to these cases, the waiting itself has become part of the consequence. And for those watching from a distance, especially those who have lived long enough to recognize the signs, it is clear that this chapter is not nearing its end. It is deepening.as if the mounting lawsuits, the expanding legal web, and the ongoing delays were not already enough. Another development has added a deeply unsettling layer to this entire situation, one that strikes not at the defendants, but at the very structure of trust that victims rely on when they step forward seeking justice. Attorney Tyrone Blackburn, who had positioned himself as a central legal figure in several high-profile civil cases connected to Diddy and his inner circle, has now announced that he is withdrawing from multiple active cases and stepping back from legal practice. For those who have lived long enough to understand the importance of responsibility and follow-through, this news lands with a particular heaviness, because it is not just about one lawyer leaving the stage, it is about the vacuum he leaves behind and the damage that vacuum creates. Blackburn represented several individuals who entrusted him with their stories, their time, and their hope for accountability, including Liza Gardner, Rodney Jones, April Lampro, and Kirk Burrows. These were not symbolic cases. These were active legal matters, some already in discovery, some approaching depositions, some requiring consistent and careful legal stewardship. When a lawyer withdraws at such a critical stage, the consequences ripple outward. Deadlines are disrupted. Their strategies are abandoned. Plaintiffs are forced to relive their experiences while searching for new counsel. Momentum is lost, and in civil litigation, momentum is everything. For an older audience, this development feels particularly troubling because it touches on a deeper moral issue. The duty of those who present themselves as advocates. We've seen it again and when someone steps into the role of a lawyer for vulnerable clients, they assume an obligation that goes beyond contracts and fees. They assume responsibility for guiding people through one of the most difficult processes of their lives. Walking away without clear resolution or transition does more than inconvenience a case. It fractures trust. It reinforces the fear many victims already carry, that speaking up will cost them more than staying silent. What makes this moment even more painful is the broader context in which Blackburn's withdrawal occurs. He had already faced criticism from judges, allegations of procedural missteps, and scrutiny over his conduct. For clients who believed in his public confidence and strong language, this sudden retreat feels like abandonment. Older audiences understand this kind of disappointment well. It is the disappointment of realizing that someone who spoke boldly when attention was high could not sustain that commitment when pressure intensified. It is the realization that not everyone who claims to fight for justice is prepared to endure the long, quiet work that justice actually requires. The practical consequences are significant. April Lampro's deposition, expected to move forward in January, now sits in uncertainty. It's a reminder. Rodney Jones's case, already in discovery, faces disruption at a critical juncture. Kirk Burroughs and others must now navigate the difficult process of finding new legal representation while their cases remain active. This is not a simple reset. It is a setback that costs time, energy, and emotional resilience. And time, as older audiences know all too well, is not an unlimited resource. For defendants, this development may appear as a temporary advantage. Cases slow, confusion increases, plaintiffs regroup. But history has shown that legal withdrawals rarely end matters entirely, and the new attorneys step in, claims continue. And sometimes the pause only strengthens resolve. What it does reveal, however, is how fragile the pursuit of accountability can be when those entrusted to carry it falter. This moment also invites a broader reflection on the legal system itself. There are lawyers who thrive in front of cameras and microphones, and there are lawyers who work quietly in courtrooms filing motions, managing discovery, and preparing for depositions with discipline and patience. Over time, the difference becomes clear. Older audiences especially have learned to distinguish between noise and substance. This situation underscores the cost of mistaking one for the other. As Blackburn exits, the focus inevitably returns to Diddy and those connected to him. While this withdrawal may offer brief relief, it does not erase the reality of multiple active lawsuits, ongoing incarceration, and a public narrative that continues to shift. Accountability does not depend on one lawyer. It depends on evidence, persistence, and the willingness of individuals to continue despite setbacks. And setbacks, as this story has shown repeatedly, are now part of the terrain. When viewed in its entirety, this four-part story is not just about one man facing legal consequences. It is about systems colliding, power meeting accountability, wealth meeting limitation, silence meeting testimony. It is about how long unchecked behavior can persist before the weight of consequence becomes unavoidable. And for those who have lived long enough to see similar stories unfold, the lesson is not new, but it remains sobering. Time is the great equalizer. It diminishes strength. It exposes unresolved truths. It brings forward the consequences of choices once dismissed or denied. No amount of influence can stop that process forever. What is happening now is not sudden. It is the result of years converging into a moment where delay is no longer possible. For victims, this chapter is not over. It is complicated, painful, and uncertain, but it continues. For defendants, the road ahead remains long, expensive, and emotionally draining. And for the public, especially those who understand the value of accountability earned through decades of experience, this story serves as a reminder that legacy is not defined by what you build alone, but by what survives scrutiny when the noise fades. As the year moves forward, more developments will come, more filings, more decisions, more reckonings. But what is already clear is that this is no longer a story that can be managed or controlled the way it once was. The machinery of accountability is in motion, and it does not respond to image, nostalgia, or power. It responds only to process. And for those who have seen empires rise and fall before, this ending does not feel shocking. It feels inevitable.